Now, because of that, then there are some other laws that relate to the law of succession. Okay, and those gives us the principles that when you are handling the matters of succession, be it tested, which is the broad. I mean, when we talk of the law of succession, what are the main branches that we talk of when it comes to the property? So you look at, is it tested in the sense that there is a will that has been left behind by the deceased person. And then if there is no will, then it becomes intestate. And what applies to that? What laws applies to intestate and what laws apply to testate? So that is how you look at it. And then now when you're asking about that, then that brings us to the second limb, the A now in probate and administration. And that is the question of how the administration of the tested property or the properties that have not been left with the will. So how is it administered? So the question of administration comes in here. So in summary, you can talk of now for you to understand holistically probate and administration, then you have to appreciate the tested, intestate, and the administration part of it. And that takes us to the three things again we talked of. Remember the acronym we talked of? Succession process, estate of the deceased, and the procedure. Again, if you have that in your mind, you are home and dry. Now, what are the legal frameworks that you need? I have said the Constitution, I have said the law of succession, I have said the question of the Marriage Act, because now, when you look at the law of succession, especially Section 2, you will realize there is the way the question of the dependents have been addressed, especially when it comes to the spouses. And that's how critical the Marriage Act will come in. And of course, Section 3(5), okay, or what is being called a spouse for the purposes of the marriage. That's Section 3, subsection 5 of the law of succession. So that's why the Marriage Act is very important. The question of the customary law relates to, especially when it comes to intestate, intestate property, so to speak, properties that have been left by the deceased without having a will. So you will find the customary law normally becomes quite critical in that aspect. So there is also the question of the Islamic law. So all that is required for you, but it shouldn't really bother you. There is a simple way you will hack this and you will be home and dry. We will revisit that when we will be going into the details. So that takes us again, when you appreciate the legal framework, then you will learn about the question of the properties that are exempted from the law of succession. So when you learn the legal framework now, and the legal framework here is mainly because it is the enabling law, is the Law of Succession Act. So it will direct you to which properties are exempted. And they have been listed there. And there is, again, I want to emphasize, be creative when you are reading. When you are being creative in the sense that always the first thing when you are reading, put in your mind, ask, what are the easy things that if I relate, I can remember, I can get hold of something. If I form an acronym that is related to something that you can easily remember because of your interaction with your environment. There are things that we are wired in such a way that they are things that we can easily remember. So when you are reading, when you are discussing in your group discussion or wherever, just ensure that you relate the concept that you are reading with something that you can easily remember. Then you're home and dry. So when it comes to the properties that are exempted from the law of succession, these are properties under Islamic law, co-ownership of the property, and nomination. So if I were you, I will look at, with those three properties that are there, what is the easiest acronym that you can form? Something that you can relate to. Then they are just at your fingertips, so that if you're asked, what are the properties that are not guided by the law of succession, you easily just pop them out because of that acronym that you have formed. So when you are reading again, just if there is something that I would really, really pray that by the end of this session, we shall be acting, then it is to have a relational approach when you are revising or when you are reading. I hope we are together up to there. Please indicate. Thank you. Feel free. Let's move together. Where you feel you are not getting it, feel free to just to air out. Now, that brings us to the end of the first 4 weeks, or the introductory aspects of the law of succession, or generally probate and administration. Now, going to the core issue. And remember, the core issue is what I talked of, the acronym September. Okay, that is the core issue. If you can remember that, you're home and dry. And that now, when it comes to E, which is the estate of the deceased. Remember, we said the succession processes, estate of the deceased, the procedures. Those are the things that are cardinal in this unit when you talk of probate and administration. Estate of the deceased, succession processes, and then procedures. Now, in that broad, the details now, the content, we said you consider the aspect of tested succession, intestate succession, and then the question of administration. Now let's look at the first part of this unit. Tested succession. Tested just means having a will. When we talk of the deceased having left a will, or I want to believe, my assumption is that by this time, at least all of us know what a will is. And therefore, when I talk of the deceased having left a will, then that property or his properties now become tested property because they have the will. They have been provided. And the will is the main document that the deceased has prepared in relation to his properties. And it becomes a will when when death has occurred. That's when it becomes a will. That is when it becomes effective. That's when it acquires the force of the law. Okay, that's when the will has become the will or has become effective. Then a codicil is an amendment to the will. So if I made a will before I got married, and then I get married now, then I will make an amendment to my will. That amendment I will make to my will if I will not have revoked my will. My will is there. I don't want to revoke it. I want to just to amend something, or just to indicate that now I am married and my wife, I want to incorporate my wife into the will. Then I will make what is called a codicil. So a codicil is part of the testamentary or the tested succession. Or now that all the properties will be subject to the will if the will is valid. And how is the will valid? A will is valid if it complies with the law, with what has been provided in the law. And that law is mainly the Law of Succession Act, especially Section 5. Section 5 has provided the elements of a valid will. So that's when we say a will is valid. Or if it has not been contested, then yeah, that will is valid. So, and the codicil, that makes tested succession. So what is more important is that you need to know the definition of the will, the requirement that are necessary for a will to become effective. Yeah. So you need to appreciate those elements. Again, how will you appreciate the elements? And the easiest way, something that worked for us, is just being creative. Identify the essential things that will make a will be valid and find a way of committing it into your memory. Your own way, something that is unique to you, something that will make you remember. Because something that is unique to me may not be unique to you. So if I give you something that is unique to me, it's not a must that you will remember. But if it is something that is unique to you, you will easily remember. So that's why I am emphasizing the question of being creative when you are revising, when you are in the groups, whatever. Just relate things for your good, and your life will be so easy. So the physical requirements of a valid will, yeah, the forms of the will. When you talk of the definitions, what forms does a will take? There is a written will, oral will, privileged will, all that. Get the critical or the essential or the elements of it and commit it to your memory in the easiest way you can remember. So those types of will, commit them there. The physical requirements for a valid will, they are provided in section 11. Actually, from section 5 all the way, I think, to section 17, 19, actually 21 or 22, we'll realize it is all about wills and what constitutes a valid will. How do you revoke a will? All that, it is provided there. But there is an easy way you can easily commit them to your memory, and we shall come to that. So how do you draw a will? Drawing of the valid wills and codicils. Remember, when I talk of a will, remember there is a sibling or a child who is following the will, and that is the codicil. The codicil gives more information to the will, or can amend the will, can introduce something new to the will if the will has not been revoked. So always when I talk of the will, remember it is connected to the codicil. So actually, wills and codicil. A will is the main document. A codicil introduces something. It's another document that complements the will, especially if there is a new thing that you had not captured and you want to capture it without revoking the will. Now, so that is the much that we can talk about the wills and codicils. And I've talked of the requirements, they are provided there. The requirements are provided in the Act 1, the question of the mental capacity, the question of the age, the question of, actually mainly is the question of the age or the capacity to make the will, the question of attestation. Those elements have been provided there, the competent witnesses that are required, because for a will to be valid, they are essential things that have been provided in the law that you need to meet. So that's what succession is all about. The next thing is, now, if a will has been made, and remember we said, for a will to be effective, it only becomes effective. It only becomes effective when it only becomes effective when death has occurred. Okay, the will only becomes effective. That is the rule. You should always remember that the will becomes effective upon death. Otherwise, before death, that is not a will. Okay. Let me pick this call just a second. Hello, sorry for that. I hope I am audible. Okay, thank you, Naomi. All right, and please feel free to shout if you're not getting something. If there is a clarity you want to get, just shout and I will respond. All right. So now you have made a will, okay, and we assume that you never revoked it, and it has reached your time to disappear on earth. Then issues arise, okay? Who can now? Who can come in to sort out the issues that arise and how that can be sorted out. Yeah, it's the courts. That is the work of the court. It's the courts that actually determine the validity of the will. And the process of determining the validity of the will is normally termed as profoundment. Okay, so there are things, of course, the way the courts work is that you have to prove. Yeah, and each will or the nature of the will has its uniqueness that will be used to prove the validity of that will. Okay, and therefore you will realize oral wills have their parameters, okay, or they have the traits that will be used to prove its validity or its existence. Okay, the same applies to written wills. It also applies to privileged will. So that process of proving the will, it's a technical process that are handled by the court. And one of the process is that profoundment of the will. Now, if there is a will goes along with the executor. The person who kind of, I will say, quote unquote, implements or actualizes the will is called the executor. Okay, if it's a man, is the executor. If it's a lady, executrix. That word, it's mouthful for me. So, and an executor is appointed by the testator. Most of the time, they will indicate in the will that so and so will be the executor. So, if such a person has been provided, then he becomes the executor. If it has not been provided, then it is the court to appoint who will be the administrator in that regard. So, and for those ones that are not, if you go to tested, there will be a different term to the person who will be responsible for executing the will. But as long as the will exists, then it will have an executor. And if that person has been provided in the will, that person becomes the executor or the executrix. Yeah, that word, if it is a lady or if it is a female. Now, so the proof of the will, the key thing you have to know is that the type or the nature of the will determine the elements that will be used to prove that will, or the factors that the court will consider to prove the existence of the will or the validity of the will. In that process is called profoundment. Now, the process when you challenge the will, you challenge the existence of the will, you challenge the content of the will, you challenge which is related to the content of the will, who is the executor in that will. That is part of the content of the will. So those are the things that you challenge. When you are challenging it, that is what is called objection to the wills. So you are saying, no, the will does not exist, or the content of the will are not a reflection of what the deceased or the testator intended it to be, or the person who claims to be, he's not meant to be the one, those kind of things. So that is now the things that are normally objected in the will, and those are what is called objections to the will. And this has to be, it's normally so much anchored on Section 29, and Section 29 is just about the definition of who are dependents is, who are the dependents. And of course, Rule 67 all the way to 70 of the probate and administration rules. Now, again, because of the nature, and remember, the nature of the will determines a number of things. Yeah, because when you talk of the oral will, the timing comes in. Yeah, it has to be within a certain time. The privileged will, also the question of time comes in. The question of the active service, what does it, those are the kind of things that may be the grounds for objection. So the nature of the will really determines even the form of the objection to that will, if at all such a thing arises when the eventualities happen. Okay. The question of the procedure, remember the crust of probate and administration is the three things. Remember the short form of the month of September, the three things. So that even when you are given a question, read that question and identify the elements of the three things that we have said. Yeah, succession processes, the estates of the deceased, and then the procedure. See, it will always revolve around that kind of thing. Okay. Then the other thing that when it comes to the question of tested succession or even intestate succession, you'll come across the concept of reasonable provision. Okay, it applies to both actually. It applies to tested, but it's more prominent in tested succession than in intestate succession. So what is reasonable provisions? These are actually, it normally applicable most of the times to those who have not been provided in the will or those who are not direct bloodline of the deceased. So when it comes to the question of inheritance, so reasonable provisions comes there. They say, I have not been provided adequately, or I have not been provided, you want the court to consider you because you have not been taken care of. So there are criteria that the courts have developed that really helps in determining the question of or the application for reasonable provision. That is provided in section 26 to 30. You will get it there. The Law of Succession Act. It is the mother law. It's the mother law when it comes to probate and administration. So that brings us to when you reach the point of application for reasonable provisions, that brings us to the end of tested succession. Tested succession and its administration. It just brings us to the end of that. But remember, in all these, just remember, what are the components of probate and administration? That's short form of the month of September. That will make it easy for you. I think month are something that is common to all of us. And that is just an example of being creative when you are doing your revision. Try to be creative, funny, cheeky. It helps a lot and it saves you a lot of stress. So now, the next thing that we will deal with is a question of intestate succession. And here, intestate succession starts from section 32 of the Law of Succession, LSA Act, Law of Succession Act. Now, there are those rules that you really have to commit it to your mind and be creative in a way that you will know. It becomes easy for you to apply those concepts if you are presented a question in that regard. So in your reading, see how you can easily, according to your context, commit those rules to your memory. A minute, again, just 2 minutes, I'll be back. Sorry. Yeah, thanks for your patience. Let's now, or before I move to the tested, any question, please? Any clarity you may require? Any clarity? Hey guys, you are too quiet. Can somebody speak, please? Yes, Naomi. The floor is yours.
Okay, thank you so much for what you're doing. I'm so grateful. And I had just one question when I came here in regards to, and I think you said that you'll go deeply into it. That part of section 3.5, like it's really confusing, especially where there's a woman, where there's marriage, like a Christian marriage, then a customary marriage follows. Like what happens to this customary marriage? I think that is one of the questions that I had in mind.
All right. Yeah, that is always there for as long as you are in KSL, that is always there. But what is important is the marriage, all the marriages, the starting point is that all the marriages that have been provided in the Marriage Act 2014, I think. I don't think it has been repealed. It is still there. There are five, yeah, there must be five or six. Actually, there are five marriages. Yeah, there is the Hindu, the Christian, the Islamic marriage, which one? Hindu, Christian, Islamic, customary marriage. Which other one? Yeah, I think they have provided there. At least I know those four that have been provided there. Then those are the standard. The law has provided for them, so they are easy for you. If you interact with the Marriage Act, they have provided the criteria that are there. Then now, then the one that comes in is the presumption of marriage. Remember, there is a new case that was released last year by the Supreme Court. I think PMK. There is that one, presumption of marriage. It just builds on Hortensia case. It just makes it more broad. So, and then now, section 3.5 is quite interesting, and there is the history behind that. And we will delve into that. It will be clear as we progress. Now, from today is just us covering the course outline and sharing something. But I agree with you, Naomi. It's always a very interesting issue. It boggles the minds of almost everybody who comes to KSL. Yeah. Thank you. For now, just hold on there. It will be clear. It will be very, very clear. Yeah. Yeah, most welcome. I get that. Any other question or clarity that you would wish? I see there is a chat. Let me just look at that. Yes, yeah, it is that case. Yeah, you're right. M and K. It keeps on. I always get a bit confused with the way it's written. It is that case. If you go through that case and also go through the case of Hortensia versus public trust, you'll read the two cases together. You'll get a broader, it will be sufficient for you to address that question of presumption of marriage. Now, I hope I'm permitted to proceed. Again, I want to emphasize there is no one, every response here is correct. We only justify. So don't feel like there is a standard answer. That is not the case here. So you give your opinion. Just be free to air out what you have. No one can, I hope you are getting what I'm saying. So now let's just go to run through in the next 1 hour or less than that, we should be through with this. I want to use the next 30 minutes to be through with the remaining part of the course outline, and then you can ask any question you have, be it maybe a piece of advice you will wish to we share with you, that will still be okay. And then we conclude before 10. Now, the next thing we have to look at now is the question of the tested succession. I said tested succession, this is where the deceased person has left no will. There is no will. Okay, and I said when I talked of a will is the first thing, and if that will has been amended, then it can only be amended by a codicil. Okay, there is a codicil that has been created to amend the will. So the will and the codicil go together. Now, where there is no will, you don't expect to have a codicil. Okay, so a codicil only exists where there is a will. Okay, so where there is no will, then that property automatically goes to, it is declared to be intestate succession. And there are rules that will guide the question of tested succession. Okay, and tested succession become very, very important when you consider section 29. Because section 29, those are the primary dependents, the dependents. The property, always the beneficiaries are dependents, and dependents have been provided in section 29 of the LSA, Law of Succession Act. That's in short LSA, section 29. So it is so critical when it comes to intestate succession. Estates that have been left without a will, okay, that is tested succession. Now, so here, beside the section 29, and if you look at section 29, it talks of the spouse, it talks of the children, it talks of actually they have been outlined there. I don't want to go reading it. You can read it, because we shall revisit it when we will be talking about the tested succession in details. Now, what is the effect of marriage on succession? When you are talking about intestate succession, so you consider the effect of marriage. This is where now the effect of marriage comes in, because of section 29. Remember, when it comes to, there is an implied hierarchy or ranking in section 29. So the spouse always becomes the first beneficiary, or the first person entitled to the estate of the deceased. So now the question of who is a spouse, becomes very critical, and that is where now the Marriage Act becomes very, very cardinal, if there is such a phrase, or it becomes cardinal. I think plain English people will say the Marriage Act is cardinal. Now, it is cardinal because it defines who is a spouse. And a spouse, anybody who falls under the marriage provided in that act is qualified. He's a spouse. Let me put it like that. He's a spouse. Anybody who celebrated the marriage with the deceased in accordance to the stipulations provided in the act, in that act, all the types of marriages that have been provided there, then that becomes a spouse. And that is the first effect of marriage on succession. Number two is the question of matrimonial property, okay? That matrimonial property thing, especially, and matrimonial property, by the way, it's not that cardinal. Just I want to correct that. The question of matrimonial property is not cardinal in succession per se. It's more relevant when it comes to the question of divorce. That's where the question of matrimonial property comes in. But in succession, succession is just the question of a spouse, marriage. Was the marriage valid? Was the marriage existent, or was not? Then that person becomes the spouse. And in that case, then the implied hierarchy in terms of beneficiaries, then the spouse comes in there. So that is where the effect of marriage is very, very important. So try as much as you can and to refresh yourself of the types of marriage that are provided in the Marriage Act, okay? And the elements, the legal elements in those marriage, the legal elements in those marriage. Just familiarize yourself with it. And again, be creative. I want to emphasize that. Be creative when you are reading it so that you can commit those elements in your mind with a lot of ease, and you will enjoy life in Kenya School of Law, and even when you are doing CLE, you will enjoy. Okay. Now, after, when you talk of the other question in regards to marriage on succession is now Section 3.5 of the Law of Succession Act. Section 3.5, and that is again what I was explaining to Naomi, and it's something that we really need to be cautious about. There are case laws that have expounded, and you can only appreciate Section 3, subsection 5, when you read the history. And that history is provided by reading the case law. They are cardinal case laws that are there. And those case laws, for now, I can't remember them overhead. There are a number of them over time, building on that concept of the woman under Section 3.5. When you get that history, then you will appreciate what is the effect of this section. Okay, we will delve into details when we go to the substantive, when we go into probate and administration substantively. But I want you, and this is my advice, there is this book, either the book by Angote or choose any of those ones. If you read the book, that book by Angote, or the Law of Succession book that has been written by Musyoka, the two guys, all of them were judges. If you read that book, those books they have explained even the question of Section 3.5 in a very simplified way, and you can really appreciate they have given that history. So stick with one book. If you take the Law of Succession book by Musyoka, stick with that book and finish it. Create time. It is doable. You just need to create time, go through that book and finish it. And be creative when you are reading that book. Trust me, you will have CLE with a lot of ease. You will be enjoying when you will be doing that paper. You will just be smiling because the things just come in when you read with a lot of creativity, when you are reading that book with a lot of creativity. And again, when I talk of creativity, what I'm saying is, if you see the elements, if you are seeing the elements, you have been provided with the element of something, please take time, associate those elements with something that you can easily remember, so that when you see those elements as a narrative, then that creative acronym that you created, or whatever story that you had created, you have related with those elements, will just come in your mind, and you will just download them like the way you download documents in a computer. Yeah. So read it with whichever book you take. If you take the book by Angote, you take the one for Musyoka, you are home and dry. They are good books. So they have explained woman under section 3.5 for the purposes of succession. The woman under section 3.5 was created by Parliament. And that is, I think, the first amendment that was done to the first amendment that was done to the Law of Succession Act. Right. So we have the goat wife. The goat wives are the ones that have been provided under the Marriage Act. Okay, they got in the sense that, I mean, they don't struggle, they are recognized automatically. And then there is the M&K, the one that has been created by M&K case, that is the presumption of marriage. And then there is the woman for purposes of succession, which has been provided under section 3.5 of the Law of Succession. Then, in as far as the question of intestate succession is concerned, there is also the definition of children. Who are children? You see, the children here are not the one that has been provided as by the Children Act. This one, children in the sense that they are the beneficiaries of the deceased. Okay? And the first one is the one that has been provided in section 29. And that's why I'm saying section 29 is so, so important. And don't go to the orals if you have not mastered section 29 of the Law of Succession. When you will have the oral exams, it's almost 90.99%. They will ask, if you get those lecturers that teach probate, they will ask you about section 29. It's so, so important. The reason is, when it comes to intestate succession, that section defines the question of the spouse and the question of the children as, you see, the implied priority or the ranking that is provided there. So here, there is the direct children, the ones that has been sired by the deceased. And there are those ones that have been adopted. The adopted child, adopted from the legal point, adopted by following the procedures of the law. Yeah, that the adopted child and the biological child, they are at the same level when it comes to succession. They rank the same. There are those children that are as a result of probably they were being supported by the deceased. Those ones will come in under the reasonable provision section. That is the group that is normally covered there. They have to prove. Proof is required for them to be considered. And that is when it comes to the question, when that question is before a court of law. Now, so that is as far as the tested successions is concerned. Now, again, when it comes to intestate succession, sorry, did I say tested succession? I need to correct that. It is intestate succession. But remember, we are dealing with intestate succession. So if by the sleeve of the tongue, I talk of tested succession, just know that I'm referring to intestate succession. Now, when you talk of tested succession, now I'm referring to tested succession. In tested succession, the will kind of, all right, the will kind of protects the estate of the deceased. That is when you are talking about tested succession, because the deceased has provided everything in the will, including who is to manage, and that is the executor or the executrix. But now, when it comes to intestate succession, it is tricky in the sense that there is no, this person has died, so the property just remains there, and you know the law has to protect that. Okay, and therefore now here, and this law even protects the tested. Only that in the tested case, it is a bit easy to identify intermeddling. So now the law has created a concept called intermeddling as a crime to protect the property of the deceased or the estate of the deceased. Okay, protect the property of the deceased. Now, and this is provided in section 45 of the Act. So the property of the deceased is not meant to be, if when he dies, unless you have the authority to deal with that property. If you don't have the authority, if you deal with that property without that authority, then that is a criminal offense, and that will amount to intermeddling, which is criminal. Okay, so it's a way the law has provided to protect the property of the deceased. Now, who are involved in protecting the property of the deceased? The law has created that mechanism, and there are offices that the law has created to do that. One of the offices that does that is the public trustee. And there is the law that relates to that. There is an act that deals with, that has created public trustee. That office that deals with, that is entitled, is one of the offices that protects that. But because of the adequacy, there are administrative procedures that the public authorities have put in place to ensure the property is protected. And if you read the Musyoka book, they have provided those offices, those administrative mechanisms that have been created to prevent or to protect the estate of the deceased or the property of the deceased. So that is the much that we can do when it comes to intestate succession. They are the principles that have been laid down all the way from section 32, I think, to 40 something, 41, 42 there. They have provided, addressing different aspects of intestate succession, the rules that apply when it comes, if it is a spouse only, a spouse with children, children only, all that they are provided. Well, when in a situation where polygamy, the marriage is polygamous, all that has been provided. So, having dealt with the testate, intestate, now we are going to the third aspect, and it is the question of administration of the estate or succession matters. How are succession matters administered? And of course, I mean, it is common knowledge to us now that jurisdiction is everything. Yeah, when it comes to law, jurisdiction is everything, and especially when it comes to the court, jurisdiction, and even any office that has been created by law, jurisdiction is cardinal. So now when it comes to jurisdiction of matters to do with succession, the Magistrate Courts Act becomes very, very important. Okay, so here you have to interact with that act, especially the sections that touch on succession interact. They have provided jurisdiction. And remember, jurisdiction is of different types. Okay, I'm sure in civil litigation that has been addressed. So jurisdiction is very important. The starting point is the Magistrate Act, and from there now you will advance to the superior courts. Okay, so that is an aspect of administration. The courts are very important. The public offices that have been created, they are very important, and it boils down to the question of procedures. Remember, we said when we were starting, I said, when we are talking about probate and administration, there are three things. It's just those three things: the succession process, estate of the deceased, and the procedures. Procedures is the question of administration, and tie that with jurisdiction. That is the whole concept of probate and administration. So now going forward, we will delve into the specifics and even the case law, the pertinent case law that we need to kind of deal with. And I'm sure you already have some of those. You have already been given some of those case laws, and the emerging things, the courts are churning out laws, especially the Supreme Court. The decision, of course, because of the question of Article 163. So permit me to stop there. I had promised that within the next 30 minutes, I should be done with that. And I think I have arrived to that point, or at that point, and I want now to dedicate the next 30 minutes or so to any question, any clarities that may arise from there, and anything that you want to know in as far as probate is concerned, I will attempt to answer. Thank you for your audience. I submit the floor to you now. I'm waiting for any question. Yes, Wekesa, please go. Go ahead, Wekesa.
Yes, good evening. I have a question. So there is this issue under the contentious probate. I'm not sure how to apply the civil procedure rules vis-a-vis the law of Succession Act. How do you go about it? Because I believe there is a point whereby you have to use the civil procedure rules.
Okay. Let me check. There is a chat. I'm just what's happened? Sorry. Yeah, Faith. Go ahead, Faith.
Good evening.
Good evening.
Thank you. So my question is on section 3.2, which talks about the children, and then it mentions something like, for a female, a child born out of wedlock. So my question is, if this female is married to the person and then they divorce, is this child still considered a dependent of the man?
Yeah, that's noted. I will respond.
And if at all they do not divorce, but then the man dies, but then it's discovered that they were not married in a correct manner, or rather the woman is not considered a wife, is this child still considered a child? Thank you.
All right. That is noted, Faith. Do you have okay. Do you have another question? The reason as to why I want to have all the question is, yes, Violet, so that when I answer them, sometimes I may end up spending a lot of time in one question and people may not have the chance to ask another question because I may consume the entire time trying to explain. All right, Violet, go on. Violet Kerubo, were you intending to talk or that was inadvertent? All right. I will assume it was inadvertent. Okay. Oh, sorry. A microphone. I get you. The microphone has a problem. You can use the chat. You can use the chat. I will try to answer these questions. Okay, Kitwanga, sorry. Martin, the floor is yours.
What happens when the testator tears or destroys the will, but he does not destroy it fully? Maybe tears it into several pieces.
Destruction of the will, eh? Okay. Destruction of the will. Aha. Thank you, Gitonga. Let me check the chat. Kerubo. Violet, can you make use of the chat? All right. On the first question, I'm sorry I didn't indicate your name. I didn't indicate your name, but on the first question of the relationship between the civil procedure rules and the matters of probate. In the civil procedure rules, there is an order. There is, yeah, it's the order. The order, and then the order has the rules. Okay. There is one order that is, I can't remember the order. I think it should be, was it 45? I can't remember. But there is the order that has been dedicated to matters to do with probate, and they have actually indicated there. There is an order in civil procedure. So, but the primary rules that you need to apply when it comes to probate rules is the probate and administration rules. Those are the primary rules that they are provided the procedures that you need to follow when it comes to administration of probate matters. But there are exceptions. There are exceptions that are covered in the civil procedure rule. So to that extent, the civil procedure applies. And of course, remember, probate and administration, these are probate, succession matters are civil matters. So they will be guided by the Civil Procedure Act in some instances. Civil Procedure Act will apply together with the civil procedure rules. But when it comes to the rules, probate and administration rules is your second port of entry. Second port of entry in this sense, because the Law of Succession Act becomes the first port of entry. Or if you are considering the Constitution becomes your primary, the first port of entry, and then you go to the Law of Succession Act, and then you go to the probate and administration rules. Thereafter, you can go now to civil procedure rules, especially the order that is applied, that expressly provides on matters that are related, that are succession related, so to speak. So I hope I have tried to shed some light that will be helpful, but together we'll walk through the journey and it shall be clear. Okay. Yeah. Then the second thing, the second question was that from Faith, a question on the child born out of wedlock. A child is a child. And remember, we said the primary or your first port of entry when it comes to the question of succession is the Constitution. How has the Constitution defined the child? The Constitution has not differentiated who is a child, that there is a child is the one who is born within the wedlock parameters, or a child. No, it has just said a child. So the Constitution has not distinguished or separated that this is a child and this is not a child. And even the Law of Succession Act now, the Law of Succession Act, the way that has defined a child, it has not, it's just, the question is that your child? Now, in this case, when it comes to the lady, that is her child, whether it is born out of wedlock or not, that is her child. So when it comes to succession, that child enjoys all the privileges, the beneficiary status of a child as per section 29 applies to that child. Now, when it comes to the dad, you will consider the context. How was the father relating to that child that the wife came with? You get, when this lady met with this man knew that this lady has a child. Now, how was this man relating to that child? Okay, did he take that child as his own? Did he adopt that child? Things to do with, like, let's say the registration documents of that child reflect that man. Yes, that man did not sign him, but the registration document, and that man never objected. That man was paying school fees. That man, even in the insurance cover, if that man was employed, or even in the current setup where the insurance cover is applicable to all, medical cover, all those kind of things, the court will look at the context, and then they will now determine for the man, if that man is not the father of that child, what was the relationship? What was the context there? Then that will determine the question of beneficiary, or the question of reasonable provision when it comes to that child. But for the mother, for the woman, huyo ni mtoto wake, hata kama alizaliwa outside the wedlock. I want to believe I have attempted to make it succinct. Okay, thank you. Now, yes, there was, sorry, I don't know, there was, I want to believe, was that related to the question of section 3.2? I think that was related to that section 3.2 of the Law of Succession Act, and it must be read together with section 29, where it defines who is a dependent. Who is a dependent? All right, now let me move to the next question, the one for Martin. what happens when it comes to the question of destruction of the will? Okay, the law requires what the law, the principle is destruction of the will has to be the intention. You remember the intention that you had when you are making the will. That intention, the requirements that were required when you are making the will, those, the capacity to make a will. You are considering about the capacity, and capacity here is in terms of age, in terms of your mental capacity. Yeah, the free will, it has to be the free will. So those requirements, yeah, those requirements that you had when you are making the will, they are the same requirements that are required when you are destroying the will. It has to be succinct, it has to be clear to the whole world that you have destroyed it, okay? So, and in fact, when most of the time, even the CLE question, and even in the orals, the way the lecturers, unless somebody is just malicious, they will make it, they will draw that distinction. Even when they're explaining to you, you will get that intention to destroy the will be clear. If it's not, then that will has not been destroyed. Let me take you an example. This person has, shredded the will. Okay, let me not use the word shredded, because when you are shredding, you will not, assuming that you are using a shredder, then you have completely destroyed it. You can't really connect. You can't connect those shredded in any. But if you have torn it into pieces and you have put those, you destroyed it and then you put it somewhere, you preserved it. You preserved it, no? And then somebody can reconstruct it. Like that case of, was it Cheese Joy? I think that case of Cheese Joy, you will read about it. If the person can reconstruct it and read it, okay, after reconstructing it, then the circumstances of shredding has to be understood. What informed the shredding? Was the mental capacity of the person, was it affected? Was it out of free will? Because destruction of the will has to be total. It has to be total. Your intention was so clear that you wanted to destroy it. But if it is because of a misconception, yeah, like you had provided for me to be the beneficiary, and then somebody comes falsely, and it will be indicated there that somebody came falsely. Somebody falsely came and tried to tell you, Elim did this to you. It's a false allegation. It will be indicated in the narrative that will be given, the context that you will be provided, that blah, 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 he did this and this, and it was false. It will be indicated there. And then you shredded that in the process. When the profoundment of that will be done, that fact of that was a fraudulent, it was a fraudulent destruction of the will, and that will can be recollected, that will be valid. But if there was a clear intention that the deceased, the testator, wanted to destroy it, and the testator is, in this case, is the person who made the will. The person who makes the will is called the testator. Then that will is not destroyed. The will is still there. I don't know whether I have attempted to answer your question, Martin. So the destruction has to be clear. The intention will be made clear to you. You will not mistake it with anything. It will just be, the circumstances that you will be provided with will show you whether it was intentional or not. Martin, have I tried to make sense of your question?
Yeah. Thank you.
All right, most welcome. So, let me check. Please explain the relation of section 3.5 to Section 29 of the Law of Succession Act. Okay. This is the relationship, and this is the history. Over the years, you know, if you read the Law of Succession Act, the assumption is this: because of the history, we are Africans, you know, we are Africans. That law is, if you read the Law of Succession Act, it is, how can I call it? Let me call it patriarchal. Yeah, it is man-centered. So the assumption is that it is men who own property. It is the man who dies first, you know. It is the man who can marry, okay, and the marriage is, you know, the legal marriage, you know, that kind of thing. And therefore, the law, even the way it had been designed, it was that it only recognized registered marriage and customary marriage. Registered marriage will be religious marriage, all religions. When I talk of religious marriage, Islamic marriage or Mohammedan marriage or Islamic marriage or Muslim marriage, whatever. That Mohammedan marriage, the Hindu, the Christian, the African, all that. And of course, the presumption marriage, the marriage that has been presumed, or the presumption doctrine. So, if you cannot prove that as a woman you fall within those parameters, that your marriage is registered, the court has presumed that you are married, you fall under the religious marriage, you will not inherit. So now, the educated people could, when they get educated, let's say you come to the university, you are married back at home, you had a wife, you are married officially, and you had a family, then you have come to the university, okay? You school and you meet your colleague in the university, and you come together, we stay, and you stay together, okay? You stay together. Then you get children, right? You have done a lot of investment, and this investment were registered. Please mute, unless you have a question. Just check your mic. Check your mic. Then, so unfortunately, the man dies. Now, when the man dies, what used to happen is this: the woman in the village will come and take everything. Now, this woman who has stayed with the man in the city, they have had children, they have done a lot of investment. That woman was not recognized in law. He was not recognized as a woman. And therefore, the woman loses on inheritance like that. So, Parliament, after several those incidences increasing, and you know, and of course, the influence of the woman empowerment movement also. Then Parliament had to amend the law to introduce that Section 3(5). Section 3(5), this is a woman who will not meet the criteria to be declared a spouse to inherit as per Section 29. Remember, the criteria there is the Marriage Act, which has provided the marriages that are recognized in law, and then the Hortensia case, that is the doctrine of presumption of marriage. That doctrine has been reinforced by the Supreme Court in the decision of M and K. I don't know why I keep on saying P. I mean M and K. That decision. Read those two decisions. The law only recognizes those ones. So this woman does not meet the criteria that will place her among those legal principles. Okay? The law of succession recognizes that woman in this sense. Okay, this woman, you just need to provide evidence as a woman that I was with this man. We have said watoto. You know, the court will take your context as a woman and relate it with your relationship. That context will be applied to determine whether you meet the stipulation of section 3.5. And once the court declares that you fall within 3.5, then you will be entitled to inherit. Okay? You will be entitled to inherit. So the simple definition I will put in drawing the relationship is this. This woman does not, when you put this woman under the criteria provided by the Marriage Act, she will not qualify to be the spouse. If you put this woman under the criteria of the doctrine of presumption, she will not meet. Okay? But there is evidence that this woman was living with this man. This woman contributed to the property that this man had. This woman, you know, there is that, but that evidence is not sufficient even to do the presumption of marriage. Then that woman will fall under section 3.5. If there is evidence that she was relating with this man, the deceased. Okay, I want to believe that. Please indicate in the chat if that has shed some light. It may not be conclusive, but by and large, we'll be moving towards that delimitation, clear delimitation. Yeah. Okay. For the purposes of succession, this is Milao Benson. For the purposes of succession, that is as follows. Amended section 29, it may not be legal as per the provisions of the Marriage Act. Okay, I think that is not a question. In case the man is married via church with the first wife, but still marries the second wife via customary, does the court also consider the second wife legally married? No. My straight answer is no. The first marriage has to be dissolved, or yeah, I mean for Christian marriage, it is monogamous in nature. So you have to dissolve it so that you can contract another marriage. That person will be liable for bigamy, I mean, which is an offense. So the straight answer is no. The second marriage is not recognized in law. The same thing, the converse applies, assuming that the first marriage you contracted is a customary marriage, African customary marriage. And then you construct the second marriage, you do a Christian marriage. It will not stand. That man is potentially polygamous. So you will just be assumed as a second wife. Okay? You will be assumed as a second wife. So the religious marriage you have done, the second one, will not suffice. So my short answer to Violet, it will not survive. That man is monogamous. Unless that marriage is dissolved, the second one will not be recognized. In fact, he will be liable for the offense of bigamy. I don't know whether it is pronounced like that or not. Yeah. All right. Naomi, please go ahead.
Allow me to interject. Yes,
Sorry,
I don't know what she was asking. Yes, sorry for that. I don't know if what she was asking is for the purposes of succession, not just the Marriage Act 2014. The question you've just
Yeah.
answered.
Okay. I think for the purposes of succession, she will just fall under section 3. She will fall under section 3.5. I think, in my view, that is a classic case of section 3.5, and not just because that certificate, in my view, it will not suffice as a source of her being validly married. It will just be the evidence that this person wanted really to make this lady his wife. Okay. But the fact that he had contracted a religious marriage, a Christian marriage, in the first instant will deny him that chance. So the best school of thought will be section 3.5. That is a classic case of section 3.5. I hope that satisfies. Is that okay? Naomi and
I think
Violet.
we can hear from the person who asked the question, but for me it's okay.
All right, Violet, you can go to the chat and just confirm that, or in the next class we can actually confirm that. Yeah. Now I can only take one question, and I must answer that question within the next 3 minutes, because I want us to be off by exactly 10. We should be leaving. Any question? All right. I just want to thank you for coming, and to encourage you. It is doable. One thing I've learned with the CLE exam, if you read and read creatively, okay, some will call it reading smartly, then you have no reason to fear. You rather take 1 hour reading one thing, but when you leave that one thing, you are okay. You will never go back. Even if you're walking from the sleep, you have it in your mind. And the only way to achieve that is to be creative. Understand yourself. If you are in a group, if a group is good for you, just use the group. But always make sure when you are leaving the group, you are better than you came. If you do that, there is no reason whatsoever to be worried. Do your best. Otherwise, our prayers are with you. We will walk this journey with you till the very end, even as we are where we are because others helped us. And we are here to help you the best way we can. We are not expert in it, but we are trying to be just like you. Learn from us, we learn from you. Otherwise, who can offer a closing prayer? Anyone? Yeah, Naomi, thank you. Just close it for us. Over to you.
Okay, thank you so much for this. We're grateful. Let us pray. So, everlasting Father, in the name of Jesus, we are in your presence this evening. Thank you, God, because of this discussion. Thank you, Lord, for enabling Elim and his colleagues, oh God, to guide us through this revision, God. Lord, we thank you even for the chance to listen to them, oh God, and even the chance, oh God, to learn from them, my Father. Lord, we pray that you may continue imparting us, oh God, with this knowledge and enable us, oh God, to retain that which we've learned, oh God, even learn creatively as we've been told, oh God. Thank you, God, even for the second term as it starts on Monday. We place it unto your able hands, God. May you go with us and guide us, oh God. For this is a humble prayer of faith through Christ Jesus. Amen.
Amen. Thank you. Have a blessed night. See you next time.